Hello guys, welcome to the MCQ series of paper 6D economic laws. My name is Ayush. In this video we are going to solve the case study number 5. Okay. So let's start with the question and answers. We are directly going to the questions and we will be reading the case study only for finding out the answer to the MCQ. We will not read the entire case study as I have already explained in introduction video. So let's start. Within how much time period the KGB shall take the physical possession of the apartment at Silver Oak Residency? This is very simple question. If you know the time period, you will directly get this answer. So let's see. So here they have given that. So what they have asked, within how much time the KGB shall take the physical possession of the apartment. Okay, so for that we have to see, yes, Sujata Builder got the completion certificate on 16th November 2020 for the project Silver Oak Residency. An association of allottees was formed in July. Okay, this is not very important. So let's see what is the legal provision behind this. Okay, so duty to take the physical possession. Every allottee, that is a flat owner, shall take the physical possession of the apartment, plot or building as the case may be within a period of 2 months from the date of occupancy certificate. If you know this question is very easy for you. So within a period of 2 months from the occupancy certificate issued for the said apartment, plot or building. So in the given case for Silver Oak Residency, the completion certificate, okay, when the occupancy certificate was issued, we have to see that. Okay, so Sujata Builders obtained an occupancy certificate on 31st August 2020 from a competent authority. Okay, so within 2 months from 21st August comes to August, September, October. Okay, so let's see what are the various options. Yes, so as you can see, option C is the correct answer because allottees are required to take the physical possession within 2 months from the date of occupancy certificate, and occupancy certificate was of the date 31st August. Okay, so 31st August to 31st September 1 month, 31st September to 31st October 2 months. So option C is the correct answer, within 2 months and up to 31st October 2020. Now let's go to next question. Whether the transaction of acquiring a property in the form of farmhouse by Rajesh Kachru in his own name out of the funds realized from impartial estate of the undivided family amounts to Benami transaction. So typically a Benami transaction is a transaction where a property is registered in the name of one person and the consideration for the acquisition of such property is paid by another person. So typically this is the generic case of Benami transaction, but if you have studied the Prohibition of Benami Transactions Act, there are certain exceptions to the definition of Benami transaction, because technically as per the legal language they are considered they can be considered as a part of Benami transaction, but they are specifically excluded from the purview of Benami transaction. That is, those transactions will not be considered as Benami transactions. Okay, so for that we have to refer the legal provisions. Okay, so what is a Benami transaction? So Benami transaction means a transactions or an arrangement where a property is transferred to or is held by a person and the consideration for such property has been provided or paid by another person. Okay, so property is transferred to or is held. So property is held by one person and the consideration for such property has been provided by another person. That is, and property is held for the immediate or future benefit, direct or indirect, of the person who has provided the consideration. Okay, except, this is very very important, except means exception to the definition of Benami transaction. That is, this transaction will not be considered as Benami transaction because it is specifically excluded, and this is a definition taken from ICAI study material. That is, it is, yes, so when the property is held by a Karta or a member of HUF, as the case may be, the property is held for his benefit or benefit of other members in the family, and the consideration for such property has been provided or paid out of the known sources of the HUF. Okay, so yes, in the given case, what has happened is that Mr. Kachru, so Mr. Rajesh Kachru bought a farmhouse in the Valley of Kashmir during the winters 2019-20 in his personal name, where he wishes to establish a party office. Okay, so he bought a farmhouse which was registered in the name of his personal name, Mr. Rajesh Kachru. So he's the person in whose name the property is registered. But what they have given is that the large portion of the purchase consideration to acquire this property was paid out of the funds realized from impartial estate of the undivided family. Okay, so if we apply the definition of Benami transactions, we can see that the consideration for the acquisition of farmhouse was paid out of the known sources of HUF, but the property was registered in the individual capacity of Mr. Rajesh Kachru. But since it is covered in this definition, exception to the definition of Benami transaction, it will not be considered as Benami transaction, because yes, in the given case, Mr. Rajesh Kachru, the consideration for the purchase of farmhouse was paid out of the known sources of HUF property. Impartial estate means impartial estate of undivided family, that is HUF property. And the given transaction is covered in the exception to the definition of Benami transaction. Okay, so since the given transaction is covered in the exception to the definition of Benami transactions, it will not be considered as Benami transaction, and yes, it will not be considered as Benami transaction. So that is, it is totally legally valid. So we have to see whether the transaction of acquiring a property in the farmhouse amounts to Benami transaction. No, it is not a Benami transaction. So between these two we have to no, this option is incorrect, because there is no such provision of Prohibition of Benami Transaction Act 1988 applies to the Valley of Kashmir as well. There is no such exception. Only option B is correct, because the property by that is, it is not a Benami transaction, because purchase of property by a member of HUF from the known sources of HUF for his own benefit does not amount to Benami transaction. Okay, so option B is the correct answer. Mr. Rajesh Kachru acquired a property from the known sources of HUF and registered that property in his own name. It is not a Benami transaction. Okay, so option B is the correct answer. Question third, whether the Sujata Builders and Developers has validly handed over the relevant documents and the possession of the common area to the Resident Society of Silver Oak Residency within the required time frame. This is also a straight away question. If you know the time period within which the document should be handed over, this is very easy question for you. So let's see the case study for further details. Yes, as you can see, Sujata Builders got completion certificate on 16th November 2020 for the project. Okay, so as per the legal provision, handing over of the documents by the promoter. So after obtaining an occupancy certificate and handing over the physical possession of the allottees, that is, first you will get the completion certificate, first you will get the occupancy certificate. After occupancy certificate, physical possession will be allotted to the allottees. After that you will get the occupancy certificate. Okay, after that you will get the completion certificate. So first occupancy certificate, then physical possession of the property, then handing over of the document. Okay, it shall be the responsibility of the promoter to hand over the necessary documents and plans, and including the common areas, to the association of allottees or the competent authority, as the case may be, as per the local laws. it is provided that in the absence of any local law, the promoter shall hand over the necessary documents and plan, including the common area, to the association of allottees or the competent authority, as the case may be. This is very important, within a period of 30 days after obtaining a completion certificate. Okay, so documents, whatever the legal documents, has to be handed over by the promoter to the allottees or association of allottees within a period of 30 days from the completion certificate. So we just have to find out the date on which completion certificate has been obtained. So Sujata Builder got the completion certificate on 16th November 2020. So 30 days from 16th November 2020 comes to 15th December 2020. Okay, so let's see what is the correct answer. Yes, so option D is the correct answer. So they are asking whether the Sujata Builder has validly handed over the relevant documents. So the last date of handing over the document is 15th December. Let's see what is the actual date on which they have handed over the documents. So they have, as you can see from here, documents okay. So although the legal provision is correct, I'm not sure about this answer, because they have handed over the legal documents on 28th December. Okay, so as you can see from here, they have handed over the documents on 28th December. Okay, so yes, documents including plan of possession and property were handed over to resident on 20th December 2020. I think they wanted to, there was a printing mistake, because they have given that. So we are asked whether the documents has been validly handed over. Okay, so we have to say as per the ICA answer, they have given this answer. Yes, because in the absence of any local law, the promoter shall hand over the necessary documents, including the common area, to the association of allottees within a period of 30 days from the date of completion certificate, that is 15th December 2020. Okay, so either in the given case, this should have been, the date of handing over should have been yes, date of handing over should have been 18th November 2020 for this answer to be correct, or the date of completion certificate should have been 15th November 2020, and so this would have been the correct answer. So I'm going as per the ICA answer, which is D. It is correct. Okay, so legal provision and logic is exactly same, but there is some doubt regarding this date, okay, which is given in the case study. Next, whether the decision taken by the committee of the creditors of liquidation of SR Auto Parts Limited is legally valid. Okay, so let's see. Yes, so from this part of case study, they have asked this question. GB Reddy is keen to survive the business and is eagerly waiting for a resolution plan from the resolution professional. But in the first meeting of the committee of the creditors, the interim resolution professional was appointed, etc., etc. The decision of the committee of the creditors to liquidate, very very important, the decision of the committee of the creditors to liquidate the SR Auto Parts Limited with only 71% of the voting share of the financial creditors. Okay, so for liquidating the SR Auto Parts Limited, they have got the approval of 71% of the COC. So let's see what is the exact legal provision. Okay, so this is the legal provision. The committee of the creditors in the first meeting by the majority of vote not less than 66% of the voting share of the financial creditor, either resolve to appoint an interim resolution professional as a resolution professional, or to replace the interim resolution professional by another resolution professional. Okay, sorry. So as you know, 66% as you know, 66% of the 66% of approval of COC is required for liquidating the for initiation of liquidation. Here in case study they have given that 71% approval is obtained. So it is, the legal provision has been correctly followed. So whether the decision taken by the committee of the creditors of liquidation of SR Auto Parts Limited is legally valid, yes, it is legally valid, because actual approval got 71%, required was 66%, so it is absolutely legally valid. Option D is the correct answer. Question 5. Whether the act of leasing out the resort for a period of 4 years without permission from the RBI to Hong Kong based travel and tourism company is valid. Okay, so this is a very peculiar question from the FEMA. For this we have to refer the provisions. Okay, so this is taken from 5.25 page number of FEMA study material. Okay, so provided no person of Pakistan, Bangladesh, Sri Lanka, Afghanistan, China or Iran or Hong Kong or Macau or Nepal or Bhutan or Democratic People's Republic of Korea shall acquire immovable property other than on lease not exceeding 5 years without the prior approval of the Reserve Bank. Okay, so as per the provisions of the FEMA, the Pakistani person, Bangladeshi person, Sri Lankan person, Afghani person, Chinese person, Hong Kong resident of Hong Kong, Macau, Nepal, Bhutan or this Democratic People's Republic of Korea, that is North Korea, they are not allowed to acquire an immovable property in India except with the prior approval of the RBI. That is, they can acquire, but they require the prior approval of the Reserve Bank. But what they have given is that no shall acquire immovable property other than on lease not exceeding 5 years. That is, you can give the property on lease to these persons, but these persons cannot acquire an immovable property, and there is a limit for a period of which you can give the property on lease to the resident of these countries, which is 5 years. So only for maximum 5 years you can, for maximum 5 years you can give the property on lease. Okay, so whether the act of leasing out the resort for a period of 4 years without permission from the RBI to Hong Kong based travel and tourism company is valid, yes, it is legally valid, as it is given for 4 years, which is within the time limit of 5 years. So option A is the correct answer. So in this way we have completed our discussion and solving part of MCQ of case study number 5. Do share your feedback and please share this PDF file in the description. So don't forget to check out the description box. Thank you.